Good afternoon, everybody. My name is Chris Justice. I am here again to join everyone today for another Q&A of all things employment law. I'm an employment lawyer, as you see down below, with Samfiru Tumarkin out of its Toronto, Ontario offices. And as I say, I'm here today to answer as many questions as possible regarding all things relating to your workplace, work situation. Maybe it's something that you've got a question about going into a work relationship or a work environment. Maybe you've got a question about something that's going on in the midst of your employment with the company that you're with. Or maybe you've got a question regarding something on the way out, perhaps a severance related question or a package you received that you're wondering about. Maybe the offer, you're wondering whether it's sufficient or not. But anyways, do get your questions in, and I will do my best as always to answer as many as I can within the time. As many of you know as well, I usually start off the session with a couple of stories that are trending in the news that are related to employment law related issues. The first thing I was going to talk about today had to do with there's a spin-off company from IBM, Kyndryl. They had laid off a number of employees around the 2,000 employee count mark, employees being laid off. And so I thought it would be a good opportunity to sort of discuss what someone's rights are in the event of a layoff or termination, and as well in circumstances where the economic climate isn't as great, the job market isn't as great, what sort of degree of effect or impact that will have on somebody's severance entitlements. So whether you are one of these employees with Kyndryl or anyone for that matter that may be subjected to a mass layoff, which I say layoff, and what I mean by that is termination. I know a lot of people will use the term layoff to actually refer to a termination, but they should also know that layoff is technically something different and usually on a temporary basis. So when I say layoff, I mean termination of employment. And as I say, in these situations, there's a lot of mass terminations that are going on, and people need to be aware of what their rights are, what their severance entitlements are. Because if you are somebody at a company and you've been there for 20 plus years or even less, you could be looking at as much as 2 years of severance. You know, regardless of what any kind of a severance package that you get, definitely don't sign it if you're part of a mass layoff, a mass termination, or you're just a termination on a smaller scale. Absolutely do not sign any release or any document that sets out a severance package of some sort without first contacting a lawyer, without first getting legal advice. Because you may be an employee at a company for a short period of time, for a long period of time, for a little bit of time, and you may think that whatever is being offered to you is actually fair. It seems reasonable. You're getting several months, maybe you're getting more than a year of severance, but the vast majority of these situations and the vast majority of these offers are still going to be well below what your full severance rights are. And there are also special provisions and factors that apply when there are mass terminations, when there are mass layoffs. If you're somebody who's been a part of a termination or a group of people that have been terminated, a large group, then you're going to have different rights, and in fact, better rights than if you're terminated on a one-off or maybe only as a part of a handful of people. So there are also things people need to be aware of when it comes to mass terminations, and that's just another reason why if you are in a situation, you need to give us a call so that we can kind of take you through all of your options, all of your possible remedies, and all of the steps that need to happen in order to get you ultimately what you're deserving of. I see some questions in here, which I will get to in a minute. I wanted to talk about one other story from the news, and this one actually had to do with, it was a report by TD Economics that spoke to a bunch of retired workers being recalled back to work. And I wanted to discuss situations where maybe someone leaves a company or even gets let go from a company, but then rejoins that company later on. Maybe it's a few months down the road, maybe it's years down the road. A lot of times people will think that if they are joining a company they were let go from, or maybe that they had left some time ago, that they're essentially starting from scratch the second time around, that they're not going to be considered an employee with that company who has all of those previous years of service attached to them. When in fact, that's not necessarily the case. There are a lot of situations where somebody rejoins a company later on, or where there's a bit of a break in somebody's service with a company and they rejoin later on, and they're actually treated as though they had never left in the eyes of the law, which can be very important, because if you're later let go, maybe for a second time, or you leave for whatever reason for a second time, you could be considered an employee with all those other years put in beforehand. And that might mean that your severance entitlements, for example, are much greater than what you thought. A lot of times employees will rejoin a company or come back to a company, and there won't be any probationary period. They'll have their benefits activated immediately. They'll essentially be put back into the position they were in when they had last left that company, which is a bit different than how you would treat a sort of fresh employee who's starting off from day one. And so when these things happen, when somebody's benefits are reinstated immediately upon their return, or when their probationary period is completely waived, these are factors that the courts and that the law look at when trying to figure out whether or not all of this prior service they had, maybe before they left that company, gets counted for, gets factored in. So these can be very difficult and tricky questions, again, which is all the more reason why you need to be contacting a lawyer, getting some legal advice before assuming one thing or another. With that said, I will start answering some of your questions. I've got a question in from Carlos on YouTube, and Carlos is asking whether or not severance pay changes depending on the size of the company. So maybe you're working for a small mom and pop shop, you've been there for 20 years and you get let go, versus working for a large corporation, maybe a Walmart, maybe a bank, and you get let go after 20 years. Does the size of the business, does the size of your employer change your severance entitlements? And the answer to that, by and large, is it does not. Somebody who is at a smaller business and gets let go after so many years is, generally speaking, going to be entitled to the same amount of severance as a larger company. There are some differences when it comes to the size of a company, but if we're talking somebody's full common law severance rights, their severance entitlements, do not think that because your company is smaller that somehow they're off the hook, or that they don't have to pay as much to you in severance as a larger company. The courts and the law will always look at a set number of factors, main factors, when deciding how much severance someone should get. So this applies if you are as part of a mass layoff or termination, which is what I was talking about earlier, or maybe on a more of a one-off scenario. But the courts are going to be looking at the age of the employee at the time they're let go. They're going to be looking at the length of service that employee has. They're going to be looking at the position that employee held within the company. And they're also going to be looking at the availability of similar employment out there in terms of any future opportunities. So these are the main factors. And of course, if there's a contract that you've signed, you're going to want to look at that, or have a lawyer look at that as well, because depending on what is in a contract, and assuming you've signed that contract, that could also affect potentially your severance entitlements. But generally speaking, again, the size of the company isn't going to have a major bearing at all on what your severance entitlements are otherwise. I've got another question in. Kristen is asking or saying that their employer is offering either taking a lower salary or getting laid off. How should I deal with it? And it's a good question. A lot of times people sort of get option A or option B. Now, if Kristen, by what you mean in getting laid off is termination, then that's one thing. But if you mean that they're going to place you on a temporary layoff without pay, then that can be a completely different thing. But either way, if you're being told that your salary has to go down, has to be decreased, and that's not something you had signed up for or agreed to, then you don't have to be put into that position where you're accepting that lower salary. Of course, if you do accept the lower salary, even if you've signed something beforehand with a different salary, you're going to more likely be seen as having accepted it moving forward. And it's not going to be easy or even maybe possible for you to go back and ask for your salary to go back up. So you want to be very careful before agreeing to any big changes that your employer is imposing on you. And you want to absolutely get legal advice beforehand so that you know how exactly to communicate with them and make sure that you're not saying anything that could cause issues later on down the line. If your employer is offering you a lower salary or a severance package, then the question will be what the severance package looks like. So if they're terminating you permanently, they're offering you something and you don't want to accept the lower salary, it may be possible at that stage to just simply negotiate a better package, because I doubt that whatever package you are being offered, if that's the case, that it's going to be it's going to reflect your full severance entitlements. So you're going to want to make sure you get a legal opinion on that as well before signing off on anything along those lines. So Kristen, if you're in that situation, you definitely want to give us a call. I think we can be of great help and give you an idea of what your options are, and if they are going to let you go, what your severance entitlements look like. Because employees need to know, and this is further to what Kristen's saying, that employers cannot just go around making significant changes to the terms of their employment. A lot of times employers don't even give you the option. They simply come to you and they say, we're going to lower your salary, or we're going to make you have to travel longer one way to a different office or a different location, or we're going to be removing duties and responsibilities that you have, or we're going to be adding certain duties and responsibilities to your plate. I mean, these big changes can take any number of different forms, but the key point is to know that you don't have to accept those changes, and that you also shouldn't be silent with respect to those changes. You want to make your voice heard. You want to put in record what your position is, or if you're objecting to it, your objection, because if you are silent for too long and let these changes just take effect and get implemented, even despite maybe you not wanting it, your silence could also be treated like acceptance. So it's definitely something in these scenarios that you're going to want to take action on sooner rather than later, but first by getting some legal advice. I've got another question in from Tigers Rangers on Facebook, who's asking if you can get charged criminally for lying on your resume. First of all, I'm not a criminal lawyer, so I don't want to be giving any criminal advice. But if an employer catches you lying on your resume, I highly doubt there's going to be any basis for a criminal charge. Is that employer going to hire you? Highly likely not to be the case. Could the employer potentially spread word about you lying on your resume? That is possible, but there could be some issues there. So I think if you have evidence that suggests they're going around saying certain negative things about you, they may be in some hot water there, but I don't think there's any criminal charges from what I'm aware. But again, take that with a grain of salt. Tigers, it'll be best if you consult with a criminal lawyer in that respect. To the extent there's also civil liability on lying on a resume, it's going to depend on the certain circumstances. I think if it's one thing for you to be caught lying on your resume going into a job, and it's another thing for you to be caught lying on your resume many months or years into a job. Perhaps an employer has entrusted you with certain responsibilities that it wouldn't have entrusted you with had it known the truth. And maybe the employer has relied on your resume to that in that respect. And if that ends up having a knock-on effect in terms of how you perform your job or how it affects the employer's business financially or otherwise, I think that's when you could get more into a situation of liability, whether it's criminal, likely not, or civil, which might be higher likelihood. But that's probably as much as I can say on that question, Tigers. So if you have any more information, or you're in a situation where you're being approached by your employer's threatening you with something when it comes to any act of dishonesty, whatever it is, also give us a call. By all means, we're happy to talk it through. Kristen followed up on an earlier email from or a message from her on YouTube about getting propositioned with a lower salary or getting laid off. And she's saying, or they're saying that they've only been there for 1 year. That doesn't necessarily matter, Kristen. Even employees who have been at a company for 1 year could have substantial severance entitlements. Even employees who have been with a company for 1 year can also make the argument that they didn't agree or sign off on getting paid a lower salary. So the fact that you've only been there for a relatively short period of time doesn't necessarily change the fact that your employer can't generally impose big changes on you, and it still could mean that your severance rights are potentially significant. A lot of people believe that because they've been with a company for such a short period of time, that their severance entitlements are going to be very little. Maybe a year employee might think they're owed a week of severance, when in actuality, there are situations where somebody with only just a year of employment could get 6 months or even potentially more in terms of severance. The law typically gives shorter term service employees disproportionately higher severance packages than longer service employees. So that's something that people should definitely be aware of, because there is that common misconception out there that shorter service employees aren't necessarily entitled to that much, and that may lead them to not consider pursuing a particular matter of theirs. I've got another question in from Teresa on YouTube. Teresa's saying that they're a full-time employee working for the Los Angeles Unified School District, where many employees were let go for not taking the COVID-19 vaccine, and she was offered money to drop her appeal. One thing I'll say, Teresa, you've mentioned that you're working for the Los Angeles School District. If your employer or your employment situation is governed by the laws of LA or of any American state for that matter, you'll have to consult with the lawyer in that region. So I can only give advice on behalf of those who are under Ontario jurisdiction or working at least out of Ontario, maybe remotely for an American employer. But otherwise, you're going to have to discuss with those in your territory to get the best advice. If I'm wrong, Teresa, in that respect, then by all means, let me know or give us a call. And if there is more of a connection with you in Ontario or even Canada for that matter, maybe you're working remotely out of Ontario or out of British Columbia, out of Alberta, that could be something different. But otherwise, the appropriate person would be someone down in the States. Got another question in from Steven on YouTube, who's asking, what do you do if your employer has refused to provide reasonable accommodation for a medical condition? You give us a call, Steven. I think, there are unfortunately a lot of situations where employers refuse to accommodate employees. Even if there is a legitimate medical condition that only requires, a relatively modest degree of accommodation, a lot of employers will still say they don't want to accommodate. They'll still say there's too much of a burden, too much of an inconvenience. But employers have a positive obligation to provide reasonable accommodation, even if it inconveniences the business or has them suffer to some degree. There has to be what's called undue hardship on the employer in trying to accommodate the employee before the employer has any basis to argue it shouldn't accommodate that employee. And there are a lot of situations where employers have to accommodate people for several years before it gets anywhere near close to the idea of undue hardship. So, Stephen, if your employer is refusing reasonable accommodation for a valid medical condition, not only are you arguably looking at a potential severance package because your employer has breached its duty to accommodate, and this therefore would be considered a constructive dismissal, but also you're looking at an employer who might be exposed to paying additional compensation to you for human rights violations. If somebody's got a disability that's not being accommodated, reasonably speaking, then that will involve disability-related human rights damages, which would be on top of any severance or any wages that the employer would otherwise owe to you. So, Stephen, I definitely recommend you give us a call. It'll be good to also to look at the communication that is passed between yourself and the employer, maybe that's passed between your treatment providers or doctors and the employer. And you just want to get information and legal advice as far as how to next best communicate with them. And again, make sure that you're not saying or doing anything that could affect your case later on down the line. But yeah, there's some potential there, Stephen, for some pretty big damages given if in fact it's true that your employer has refused to provide reasonable accommodation. And this can apply if somebody's got a medical condition. This can apply if somebody requires accommodation due to age or due to family status. Maybe someone's pregnant, they gave birth, they've gone on mat leave, they need some accommodations in that respect. There could be a whole number of different accommodations under human rights related grounds that employees will often ask for, but that are just simply denied or rejected outright. And again, if you're in that kind of a situation, you definitely want to give us a call. I've got another question in from Nancy on YouTube. Nancy saying or asking, if an employer cuts your hours to reduce your pay instead of changing your wage, is it looked at in the same way as cutting pay directly? And yes, the answer to that in general is it is. This goes back to the idea of a constructive dismissal, which is when there's been a significant change to the terms of your employment. So if you have agreed with your employer that you'll work 9 to 5, for example, Monday to Friday, and your employer says, we're not going to change your hourly wage, but we're just going to remove 2 days a week from your schedule. So now you're only going to work Monday to Wednesday. Whether you look at it as hours or pay, there's effectively a 40% decrease right there. And so it could be a reduction in hours, it could be a reduction in pay, it could be a reduction in prestige or seniority, or as I mentioned earlier, a change in location. All of these things can amount to a constructive dismissal. And if there is a constructive dismissal, the law will treat that very similar to as if there was a termination, in which case you would have an opportunity to oppose or reject that change or that reduction and insist on being paid out a package if, for example, nothing else was feasible or you didn't want to accept anything otherwise. So thanks, Nancy, for your question. I've got another follow-up from Kristen on YouTube, who's asking if they do take legal action and negotiate severance, could the legal fee be part of the package to reimburse the employee? And generally speaking, Kristen, if you retain an employment lawyer services as part of the negotiations, there will generally or typically be a request for legal fees. Your employer may not compensate you for 100% of your legal fees, but there is always generally a request for them to compensate or at least contribute towards the legal fees, if any, that you've incurred in having to negotiate for that package. So yes, that is always a part of every deal. And most often employers will pay some money towards somebody's legal fees on top of additional severance that's achieved through the negotiations themselves. I've got another question in from Supkin on YouTube, who's saying that FedEx is merging Express with Ground and giving 90% of the work to contracted workers. FedEx is giving people like Supkin a choice to move to a new route or take 15 days severance. And they've worked there for 30 years. And Supkin's asking whether or not they can do this. So again, an employer going to an employee and giving them or sort of almost imposing a decision on them to move to a new route, that could be another form of a constructive dismissal. You may have a certain route that you followed within a certain sort of geographic scope, and then that route gets completely changed. Maybe you're doing a route in a different province. Maybe the new route they give you requires you to be on the road for a substantially longer period of time, or maybe your commute to get to the office where the route begins is a long ways away. So again, this is another example of a constructive, or at least a potential constructive dismissal to get to sort of impose on somebody a new route. Now, there is another option. Supkin's mentioned here about taking 15 days of severance as an alternative to moving to this new route. And if you've been there for 30 years, or in any event, really, anytime an employer offers essentially 2 or 3 weeks of severance in exchange for a termination package, or as an alternative to them making big changes to your employment, you're going to want to talk to a lawyer first. 15 days of severance for somebody who's been at a company for 30 years and arguably could get 24 months of severance. I mean, it would be an absolute travesty to accept 15 days only when the potential is so much greater. So if you're in a situation as an employee and you're being given, frankly, 2 bad options, either we change the scope of your job so much, or we give you a pittance in terms of a severance package. In that scenario, I would say no to both of them. And you would either have an ability to negotiate a different route or keep your old route, or if they absolutely insist that there's no way you can keep your route, yeah, you're going to definitely want to negotiate a better severance package, because 15 days, pretty much don't care who you are, is not going to be enough in terms of a severance package, especially for somebody with as many years of service as Supkin. Got another question in from Emmy. Emmy's saying that their employer has recently started taking a much larger amount off her pay for benefits. Can they do this? It has a significant impact on the amount they receive each month. And generally speaking, no, although it will depend on how much larger of an amount they remove for benefits. So, for example, if ordinarily they would take $100 out of your pay to cover your benefits plan, and now that's changed to $105 per pay, that's not going to attract liability in the same way that them going from $100 off your pay to $200 off your pay would. So there is a question of the degree to which the change happened. But again, this is another example of a constructive dismissal where you're essentially getting less money for arguably the same benefits. If you're getting better benefits, then there might be some additional consideration there. But if the benefit cost is simply increased and it's just being taken out of your pay, then again, that could amount to a constructive dismissal. Your employer may owe you also the amounts that they took away off of your pay. So this is another scenario where you're going to want to give us a call so we can make sure your rights are properly protected. I've got another question, final question actually of the day, from Paul on Facebook, who's asking whether or not an employer can require you to call in 2 hours before your shift every shift. And Paul, that may depend on what, if any, contract there is. So if you have signed a contract that speaks to you giving them heads up before a shift begins, then that can create a term, that being a term of your employment. If you haven't signed anything like that, but you have been calling in every 2 hours before your shift for a number of months or a number of years, that can also form an unwritten rule, so to speak, with respect to your employment. If it's coming out of the blue, at a complete left field, and all of a sudden your employer is asking you to call in every 2 hours, then yes, that would be a change to the terms of your employment. But would it be a constructive dismissal? I think that would depend. I think that would depend on the exact reason why they're asking you to call in, because it still has to be a significant change to the terms of your employment. And so the question would be whether or not calling in once every time you start your shift a couple hours beforehand would constitute a significant change. But without a bit more information, Paul, it's hard for me to give you the exact advice that I think you'd probably need. And with that said, I would just recommend you give us a shout and have one of our lawyers follow up with you after today's session. and I'm sure they can take you through sort of the pros and cons and what to assess right, wrong, better, for worse. But thanks again. As I say, that was the last question. I do appreciate everyone with their questions. As always, I'll definitely be back to answer more of your questions. As you see down below there, we've got another session going on with Darren Saul, that being tomorrow, 1:30 p.m. Pacific. So any employment and or disability law Q&A related questions you've got, tune in tomorrow with Darren, and he'll be happy to answer as best he can. But again, for today, I'm signing off. So everyone do take care and enjoy the rest of your day. Bye for now.